sponsors. The ACLU of North Carolina. Here we have Susanna Birdsong, Senior Policy Counsel, who is representing the ACLU. Where's Susanna? She may be just outside. Oh, there she is, great. And we also have Don Blagrove here, the Director of the Carolina Justice Policy Center. Thank you. Of course, thank our candidates, Ms. DeBary, Mr. Eccles, and Mr. Meyer, for joining us this evening. I just wanted to briefly introduce our moderator, Mr. Scott Holmes. Professor Holmes, of course, is here at North Carolina Central School of Law. He brings a really diverse background this evening. He is supervisor of a civil litigation clinic, but he has vast experience as a criminal defense lawyer, where he's represented people in state and federal court. He was also a public defender for some years. And in recent years, his academic practice as well as his professional practice in the courts centers around fascinating areas such as poverty, racial disparities, and he's very active representing the activists. So as he puts it, alliteratively, he represents panhandlers, protesters, and preachers. So we're excited to have Scott here this evening to engage in a really lively debate with the candidates. Without further ado, Scott Holmes.
All right, thank y'all. I'm really honored to get to do this. I also want to welcome you to North Carolina Central University. I know you have a lot of graduates in the house. It is an honor for me to get to teach here. This place is about truth and service, and I have the honor of trying to represent that with my students who I've seen here, and former students. Given the history of this university, born out of the civil rights movement and its mission, it feels a very appropriate place to have this conversation with these candidates, particularly where I hope to center it around issues around racial disparities, mass incarceration, things that I have a concern with and the co-sponsors have a concern with. So I want to thank you all for coming and welcome you to Central. If you haven't been here before, welcome you back to Central when you all have made this home. And I want to thank folks for letting it be my home and where I work. And without further ado, I'm going to start questioning these folks. It's not very often I get to question the district attorney or potential district attorney, so I'm going to try not to be too leaky or legal about that. I think the way this is going to work is that each of you are going to have a 3-minute opportunity to make an opening statement. I have randomly selected the order, and so it'll be Mr. Meyer, Mr. Eccles, and Mrs. DeBary in that order. Then I will ask a question, and it'll begin. You'll have 2 minutes to answer that question, and it will go in the order of Mr. Meyer. You'll get the first question, and then Mr. Eccles, you'll have the opportunity to respond. Mrs. Barry, you'll get to go then, and then I will start with a different person each time, and we'll just kind of keep circling around so the first person is first all the time. I may feel the spirit move me to have a follow-up question, and I reserve that right, although I'm not going to try not to overdo that. I may not do it at all. We'll see how the spirit works, but if that occurs, then you'll have a minute to respond to my follow-up question. And if I do start doing follow-up questions, I will try to sprinkle them evenly and not pick on anybody unfairly. So is that good? We're going to have kind of a timekeeper here that kind of tells you when you have about 30 seconds left, and then a thing that says when you're done. I'll let you finish your sentence, but not your thought, and then we're going to keep this thing moving. I also want to tell you in advance that some of my questions are pretty specific about particular policies and what you think about them, but some of them are pretty broad, and I'm going to include a lot of examples around, I think we have a bail up here too. We can get rid of that cell phone. Anyway, I'm just kidding. We'll see the problem. So anyway, some of these questions will have a lot of examples. Feel free to kind of pull out of the thread that you want to talk about. Some of these questions are so big, and the examples I'm going to give are so many, that I'm really not expecting you to hit all of them, but I think they will convey the general concern that I raise and give you some things to talk about. Other questions are pretty specific, and if they are fairly specific, I'd like you to try to answer the question and not dodge the question, as we lawyers are apt to do. So without further ado, I will give you all your moment to have your opening statement, and I'll begin with you, Mr. Meyer.
My name is Daniel Meyer. I'm an attorney here in Durham. I've been practicing for about 16 years, had my own firm for over a decade. I used to do a lot of civil law. Now I'm almost exclusively criminal defense. I've tried cases from everything from speeding tickets to first-degree murder. I'm still actively engaged in the practice of law and criminal defense. One of the things that I think we need in Durham, we've done a lot to move Durham forward, but we do need more of a cultural shift. We do need more of a change in Durham forward. We need to start focusing more on the appropriate consequences for actions and not just focusing on convictions. Convictions have lifelong consequences for many people, and it's not always appropriate. Certainly for a lot of low-level issues, victimless crimes, things like that, there could be other alternatives, community service, restitution. We also need to look at mental health, substance abuse, and make sure that we're not penalizing people for things that are largely beyond their control. Certainly on the flip side, when it comes to the violent crime, gun crimes, things like that, we need to make sure that we're handling it effectively and working the cases and moving them quickly so people aren't waiting a year, 2 years, 3 years, 4 years for their day in court. That's not fair for the defendant, it's not fair for the victims, and a lot of things can happen in that time. So I think we need to work on that overall efficiency as well. And that's one of the things that I want to look towards. We also need to use and look beyond just the criminal justice system. As the district attorney, you have a holy pulpit, you have a good position, and one of the things that we need is not just more resources for the prosecutors, for the district attorneys, we need more resources for the community. One of the problems of the poverty, crime, things like that is the lack of education, lack of resources, lack of things in the community, mental health, substance abuse. We shouldn't just focus on it and say, hey, once they're charged, let's give them mental health and substance abuse. By the time your problems get severe enough for you to have been charged, you've already gotten pretty far down the path. We need to explain why it's important to put that in on the front end. Another thing to do is make sure that indigent defense is adequately funded. Make sure the appellate defenders are adequately funded. Make sure the innocence inquiry commissions are adequately funded. We have a lot of actors within the system, and we need to work together with law enforcement, with the defense, things like that. The prosecutor can't do it alone and shouldn't do it alone, but we can make sure that everyone else who's out there is there to work with us to make sure that we are looking at the appropriate consequences for the actions and focusing where we need to be.
Thank you. Mr. Eccles.
Thank you. Good evening. My name is Roger Eccles, current district attorney. It's been my honor to serve as district attorney the last 3 years and 8 months, I believe it is. I've been a prosecutor for 20 years, had the opportunity to do most everything as a prosecutor. As a prosecutor and as your district attorney, it is my belief that we should be making decisions first and foremost that keep the community safe. We should focus on being fair and equitable. We should focus on seeking the truth. We should focus on being thoughtful to get to the right and correct and decision that serves the best interests of justice. We also should understand that we make decisions all the time, and all decisions that we make involve competing interests, and understanding that no decision that you make can make everyone happy, and many of the right decisions make no one happy. So that's what I've tried to do. That's what I focus myself on and the office on. But when it doesn't compromise safety, we need to look forward and thinking that many times what's in the best interest of the community is often less punitive measures on defendants. And with that in mind, we've been very aggressive with deferred prosecutions. I'm actually also district attorney under which the misdemeanor diversion program began. We began mental health court, and that serves as an opportunity for those individuals who have a mental health diagnosis or issue that's connected to the crime they committed, that's short of a defense, gives them an opportunity to get free, or shouldn't say free, but mental health treatment at no cost to them. And if they do that, they get their charges dismissed. We've also started amnesty program. We call it Amnesty Day, but it's not just one day that focuses on giving or restoring driver's licenses of individuals who have let issues snowball, and we were able to do that in a way that was innovative and that people were able to text in without coming to court, meaning without coming anywhere, and getting charges dismissed without any cost to them, and being on track to get their license restored. I'm told that not only are we a leader in this state, but it was the first of its kind in the nation. We've started restorative justice, so we've done a lot of things to put individuals in better positions to succeed after they come in contact with the justice, with the courthouse. Thank you.
We don't have to take your phone too.
Good evening. My name is Satana DeBary. I'm a candidate for district attorney here in Durham County. I've been in practice of law now for 24 years. I spent some of that time as a criminal defense attorney, just like Mr. Myers. I've tried everything from traffic cases to murder cases. I have actually been practicing law longer than either of these two gentlemen here, and I've practiced more complex areas of law. But I don't think that this race is about that. What I think this race is about is a cultural change here in Durham County. We deserve better, no matter who has been district attorney here in Durham County over the last 50 years. We have the same criminal justice outcomes we had 50 years ago. Doesn't matter what programs they've been running. Doesn't matter if the police are arresting more people or fewer people. We still look like Mississippi. So we can't continue to call ourselves the most progressive city in the South and over-incarcerate people because they are black or brown or poor. Here in this county that is 38% black, 80% of the people in our jail are black. Here in this county that is 38% black, 83% of the people that the police stop are black. So it's one thing to say you started all these programs. It's another thing to say that over the last 20 years, the practices of the district attorney's office have led to more incarceration of women, more incarceration of young people of color, more criminalization of the poor. I think here in Durham County, we deserve better than the district attorney's office that prosecutes people for having substance abuse issues. We deserve better than the district attorney's office that prosecutes people for having mental health issues. We deserve better than the district attorney's office that prosecutes people simply for being unable to afford to sleep inside. We deserve better than the district attorney's office that prosecutes children. A fight in school should not mean a night in jail. We deserve better than the district attorney's office who claims they can't do anything about cash bail. We deserve a district attorney who is a leader in this community around the gun violence that we do suffer. We have 90 open murder files in Durham County, some of which date back all the way to 2011. Only 7 are currently scheduled for trial. So I ask that for your support in making have a better criminal and fair and more equitable criminal justice system here in Durham County.
All right, thank you. So y'all have already mentioned it, but my first question has to do with cash bail and bond. As you all know, folks can be arrested and have to post bond to get out before they have their trial. Sometimes folks don't have the money to make their bond, but there's no hearing to determine whether or not they can make the bond once it's set. Sometimes folks miss court, and an order for arrest goes out for them, and they're arrested for a relatively minor offense and have to post bond for failing to appear. Sometimes folks under the age of 18 are incarcerated in our Durham County Jail in violation of federal law. And so my question to you all is, what are y'all going to do about that? Would you all agree for the DA to consent to unsecured bond for several specific offenses that are either civil possession, non-violent, low-level felonies? Would you consent in first appearance courts to unsecured bond for most of those offenses that are not violent. Would you agree to a system of warnings for failure to appear, so that if somebody missed court, instead of issuing an order for arrest on the first time, they'd get a letter of warning telling them to come back to court, and the clerk would reset that automatically to avoid people getting, arrested for missing court on their driver's license ticket? And would you consent to, how would you deal with a situation where kids under the age of 18 are arrested and housed in our Durham County Jail pending trial? You got 2 minutes, Mr. Mike.
I mean, I would say one of the things that I have said before is we do have an issue of too many people in the jail simply because they're poor. I've pushed it. I know I've talked with the sheriff and some others about it. As DA, we don't control bond. We don't control bail.
You can consent to unsecured bond.
You can consent to unsecured. It's up to the judge whether or not they'll do it. I would work with them. I don't think we should have secured bonds below $5,000. I think if its bond is that low, you're in there because you're poor. So we need to work on that.
So you'd agree to presumptive, for all offenses less than 5,000 would be unsecured?
That's what I would ask for. I mean, I don't know. And obviously you'd have to look at it, because I think if you have a history of FTAs, if it's a violent offense, I think some of the things we have at $1,000 bond should probably be above the 5,000. But if you're in on a bond of $2,000, that's because you don't have $200 and your family does. It's not because you're a danger to society. It's not because you're a threat. So I think FTAs, one of the biggest wastes of time for the sheriff's department and in court is having to arrest people on FTAs. The blue sheet process is fine, but that's an issue. We should do, but again, you have to work with the judges, you have to work with the clerks, do an FTA court, kind of like they do with child support every quarter. But every month say, look, if you've missed court and you have an outstanding FTA, come here and we'll get it struck. We'll get you a new court date. Obviously, the judges are going to look at it. If it's a serial offender, they may say, well, no, we're not going to do that. We have to set a bond. But I think we do need to do that, especially for the first time ones, for the low level ones. If people, if they showed up 5 minutes late and the judge refused to call a second calendar call, we need to give them an opportunity to have it addressed and have it struck rather than let them walk the streets terrified that if they get stopped for a speeding ticket or anything else, they're getting arrested on that warrant. We do need to certainly work on that on the lower ends, and that's a part of it. We need to keep people out of the jail and in the communities, in with their families, in their jobs. And not incarcerate them simply because they're poor. As far as, down to the 30 seconds, I'm done.
That's a great example.
As far as a presumptive bond of unsecured or written promise to appear, yes, I would agree that we could have more offenses or specific offenses that the presumptive bond is unsecured. Currently, class 2 and class 3 misdemeanors the presumptive is that it's unsecured. Certainly, I would agree that most class 1s, we could do that with. Some of the low-level felonies, I would agree to a presumptive unsecured, such as simple possession. Some of the other property offenses as well. I wouldn't agree that it should be a presumptive unsecured bond on a residential breaking or entering, and maybe some others, but most obtained property by false pretenses, I would. And we do agree now currently that even when it's not presumptive, that some of the bonds should be unsecured. Sometimes judges agree, sometimes they don't. So I definitely would agree with that. I've forgotten every aspect of your
What about kids in jail?
Of your
Is
question.
there anything you could do about the people under 18 who we put in our county jail?
Well, I think the age is certainly a factor, and low-level felonies, generally, it shouldn't be in the jail. It's not optimal, regardless of the crime that they're charged with. But at the same time, if it's a serious felony, you are balancing that with the safety of the community. So there could be more rules to determine, or we could go through more steps for the court to determine the tangible factors that bear on safety when it comes to children under the age of 18. But that's certainly a factor. But the level of crime that is charged is also a factor.
Thank you.
So I agree that the district attorney's office could develop a list of nonviolent misdemeanors and low-level felonies for which there's a presumption of unsecured bond. That can be developed in conjunction with law enforcement and with the judges. I don't see why there's any reason not to do that. I don't know when the last time that bond schedule was revised. So it is certainly time to look at it. I think it would be instead of the district attorney presuming that every bond should be secured and on an individual basis will make a determination about unsecured bond. I think we can flip that on its head. And in those lists of cases, the district attorney's office can have a presumption that all of those cases that the district attorney's office will agree to unsecured bond on all of those cases, and only in individual cases consider a secured bond based on the facts of the case. And I think it is unrealistic to say that if the district attorney and the defense counsel go in front of a judge and ask for unsecured bond, that the judge is going to say no. I think it is more like the district attorney has a great deal of power in this situation. And I think more oftentimes than not, if the district attorney joins in that, the judge will agree. Finally, as for children under the age of 18, I don't think a secured custody order should be issued for any child under 18. Certainly, if they have been accused of a misdemeanor or a low-level felony. For those who have been
charged with murder,
but if they've been charged with a violent crime and a secure custody order is necessary, I think they should be in a facility specifically for juveniles and not in adult populations.
All right, thank you. So my next topic has to do with racial disparities in our court system. This is something that we've been studying here in Durham and looking at the data. And what we see is that in traffic stops, people of color are at a higher risk of being stopped. We also see that people who are stopped, if they're a person of color, are also likely to be searched. We also see that when a person is stopped for a traffic offense, that can be a pretextual stop for a criminal investigation that's not related to the traffic stop, and that also is predominantly people of color. And we also see that crimes like marijuana or crimes of poverty like panhandling and sleeping in public and other things that really piss me off, those things are also racially disparate. And so my question, broadly speaking, is what can you do as a district attorney to reduce those disparities and recognize those disparities? And some of the suggestions I have for you to kick around or consider are stopping the prosecution of regulatory traffic offenses and only prosecuting road safety violations. Another thing that you could do as a district attorney is refusing to prosecute crimes that are related to pretextual stops or consent searches that look like the officer kind of went beyond the initial stop. Another thing you could do is ask officers to show up in court with their data so that they have to self-report to you what their racial disparities are in their own stops and disclose that to defense attorneys so that we know what the racial data is for each individual officer. And you could also stop prosecuting marijuana because the Duke police don't, and I don't understand why the other police here refer those cases to court when the Duke students get the benefit of a moratorium. So what do you think, Mr. Eccles?
Yeah, 12-part question.
Yeah, I got 2 minutes too.
As far as, as far as the regulatory, prosecute regulatory things, I certainly would be willing to consider that. And as far as whether something is pretextual and looks like something else, I mean, we should be skeptical on that also, and make sure that the stuff is constitutional. I think sometimes we get into a slippery slope if we're not going to prosecute anything that comes from it because we don't know what happens after that. Well,
pretextual stops are constitutional. My problem is when the HEAT team who is really supposed to be doing criminal investigations are running around doing tinting windows stops in order to do those kinds of criminal investigations. What do you think about that?
Well, yeah, I don't think the heat team exists anymore, but it
All right.
doesn't.
They have a new name.
It doesn't have. Well, I don't know that it does, but it doesn't have to. Actually, it doesn't have to be. It doesn't have to be the heat team. You know, again, if something like that happens and the fruits of it are simple possession or something like that, certainly that's something that would not be so hard to not prosecute. But we're talking about case by case basis on that, unless we are going to go forward and say everything when it could be something much more significant. And I think that's a harder bridge to cross, for lack of a better
What about
term.
marijuana prosecution?
Generally, all marijuana prosecutions.
Like all simple possession, just stop prosecuting. Like,
I probably wouldn't. I probably would not prosecute felony possession of marijuana. Currently, we do a lot of tasks and things like that. My only issue with that, if there are underlying issues that could not only help the community but help that individual, that we can take care of and still not result in conviction. Those are type things that I look at when I think of to prosecute all or not to prosecute any. And certainly it is an enforcement issue if you have one agency that does not enforce something and you have another agency that does within the community that does create something unfair. Yes.
all right, your time's up, Mr. DeBary.
You know, I've been on record saying that, you know, we know that you can not prosecute simple possession of marijuana because the Duke Police do it. Duke Police Chief will tell you that is a low enforcement priority, and they allow the student judicial process to handle that. It is generally not the case that somebody gets arrested for simple possession of marijuana because they're sitting on the courthouse steps smoking weed. They are generally charged with that from a pretextual stop. And so I think this speaks to kind of the larger issue in the office of having data and understanding what the district attorney's office is prosecuting, what it's not prosecuting, how it's making the decision not to prosecute those things. I have said before, I think there's a better way to handle simple possession of marijuana cases. You can have a prosecutorial policy that prioritizes violent crime and those crimes that are major property crimes, and deprioritizes things that are the result of pretextual stops. And I would be in favor of that.
What if a pretextual stop, hit the mother lode of a traffic amount? Would you still prosecute, even though the stop itself was pretextual or even had some basis to believe that it might be racially motivated? Would you forego the prosecution for a huge amount of, cocaine, heroin, marijuana?
I think that's a situation where the district attorney has to use the legal analysis, has to look at the facts of the case, look at the evidence of the case, and make a decision based on what has happened.
All right, so my next question.
Brandon.
Sorry, I can see how. Yeah, I guess we could.
It's not going to be vastly different. I don't think that we should be focusing on personal use of marijuana in private spaces. I think it's a waste of time. You also need to work with law enforcement. Chief Davis has said for DPD, it is a low priority. It's not something they're looking into. Duke, obviously they don't prosecute it. There's a lot of things that Duke does to protect their students, and I think that's good. Central can do the same thing. You have to work a lot with law enforcement on those issues. Traffic stops are already way down. Durham last year only issued 4,000 citations. You can work with law enforcement on make sure they have the training, make sure they're stopping these pretextual stops. We can refuse to prosecute. They're the ones who make the charging decisions. We need to work with them if we want to stop people from being charged in the beginning. So I think we have those issues. I think, like Roger said, like Mr. DeBary said, you have to look at the individual stops for the pretext, things like that. I mean, if you hit the mother lode and it's an otherwise legal stop, I'm not sure you let somebody with, 10 kilos of cocaine and 5 kilos of heroin walk just because, they were pulled over for a window tint violation. So you really can't have blanket rules. I think you do need to look at it. You need to work with the officers. You need to educate the officers. When you're seeing these issues with the officers, explain to them what the issues are. Explain to them the training. Explain to them kind of what the changes need to be done. And we need to work with everyone in the system. We've got, I think, 4 agencies within Durham County, probably more than that. We've also got the judges who are also all independently elected, and we all need to kind of get together and try to work and set some of the priorities. We have some judges that won't convict on marijuana. We have some judges that gleefully convict on marijuana. We need to all kind of try to come together and do it. But I would agree that I don't think personal use of marijuana in private spaces is something we need to be wasting time with.
What do you think about officers having to self-report their racial disparities in their data and show up to court with their own little report card on how their stops and arrests and searches are?
I think you would have to be careful. I think you'd have to be careful with that simply because you have to take it out of context. You have to look at the context. If you have an officer whose beat is McDougal Terrace, and he's stopping more blacks than the person whose beat is Trayburn, you can't necessarily say that's because he's being racist. So I think you have to be careful on how you present the data. I think if it comes to the prosecutor, if you want to look at it and educate them, that's fine. But you can't just do a blanket and say, this officer who works in this area stops more blacks, this person stops more Hispanics, there's something wrong with them. You have to look at the areas they work.
All right, thank you. So now the next question, my apologies for rushing through that. One issue that greatly concerns me, I work with families who have been victims of police violence. I've represented people who've been tasered and permanently disabled. I've represented people who've been beaten. I've represented helped families understand it when their families have been killed by police in Durham. And one common pattern that I see is that officers will stop someone without reasonable suspicion. They will just basically jack them up and shake them down with no constitutional basis. And when the person argues with them, they will charge them with resisting arrest, sometimes with assaulting a government official, falsely. And then when I go to trial and I get it dismissed and the judge finds there was no reasonable suspicion, and dismisses the case because the court recognizes there was no basis for that stop, the officer kind of walks on their way. My client has been beaten, arrested, and has now an arrest record but not a conviction record, and nothing seems to happen to the officer. And so my question for you all, and then the second part of the problem is that when they commit serious crimes like murder or a serious assault, the district attorney seems to be, and this isn't just this district attorney but across the state, give police the benefit of the doubt that they don't give regular citizens. So instead of just arresting on probable cause, the officer gets paid leave for a week, gets to meet with a lawyer, then give a statement, then gets to assert self-defense to the person that's going to charge them before they are ever charged. Whereas my client, who's not an officer, gets arrested immediately, sits in jail for 2 years, and then has to put their self-defense claim on at their trial. And that officers who kill people get a different kind of scrutiny than regular folks. And so, would you all prosecute police officers who detain people without reasonable suspicion and prosecute them for simple assault and false imprisonment, which is what the crime is? And would you consider having the AGs prosecute or look at cases to prosecute after the SBI has done their investigation when police kill people? This is the time you start.
So I'll answer the first one. The last one first, which the answer to that is yes, after the SBI has. I have said this before. I think that all cases of homicide in Durham County should be investigated, irrespective of who committed that homicide. And that I would not be opposed to bringing in the AG's office to prosecute police who have killed people. As for the simple assault and false imprisonment charges, I think on these cases, we have body cameras now. We have, I do not object to prosecuting police. I do not object to taking in the evidence, taking into account what has happened. I represented a lot of people who were charged with resisting public officer who just asked why they were being arrested. And We see constantly through social media, on the news, that these routinely happen. And so I think we have to also have some communication with the police chief of all the departments, because as Mr. Meyer said, there's more than just one city department. There's more than one police department and the sheriff's department, and really talk about how we're going to handle these cases moving forward.
All right. Mr. Meyer.
I mean, I think you do need to look at the investigations. You need to look again, as all of them, it's hard to do a blanket rule. If the police break the law, the police should be prosecuted. But like everyone else, one, some of the benefits that they get as far as getting to talk to a lawyer and things like that are statutory. We can't change that even if we wanted to. The General Assembly gives them that status. We can't say, no, we're going to take it away. That being said, if it is the serious crimes, you know, officers have been prosecuted. In Durham, I've represented officers who've been prosecuted. If you find the crimes, I think you do prosecute. You've got to hold them to the same standard. Now, would I just because a judge says a stop is bad, automatically say I prosecute it? No, you still need to investigate it and make sure it was criminal. Because there is still the difference there. I think more serious cases...
Well, what is the difference? If a judge has said there's no constitutional basis and the video and the officer's testimony at trial basically admits there was no reasonable suspicion for the crime, what is the difference?
I mean, you still have to look at it. I mean, everyone gets the presumption of innocence. I can't say on a blanket one. If there was criminal acts, then I think they should be prosecuted criminally. If there's not criminal activity, then there's not.
Would you hold them to a higher bar? Like, require more evidence before you prosecute the police than you would someone else?
I mean, you would need to have the same belief that you do that you should prosecute for anyone else, which is that you can prove the case beyond a reasonable doubt. I think one of the issues we do have, and we've said it before, and you've seen it too, is we do tend to keep some people, we hang on to cases longer than we should. And I think whether it be law enforcement or anyone else, we need to analyze our cases a whole lot earlier, look at the evidence, look at the strengths and weaknesses of cases, and decide whether or not we should be going forward so someone's not sitting in jail for 2 years before we dismiss their murder case based on stuff that we've had for 2 or 3 years. So I think I would definitely do that. For the higher level stuff, I think it would make sense to bring in the AG's office for officers to, or have them investigate and take over prosecution, certainly for the more serious stuff. Because as the prosecutor, we do have to have a relationship with law enforcement, and I think there would be benefits to having an outside, just like we have the SBI actually investigate, which North Carolina does, which is great. You see too many of these jurisdictions where they investigate their own. I don't understand that. I think you should look at that for some prosecution, certainly for higher level stuff as well, so you're not prosecuting your own.
Thank you.
I think as far as prosecuting officers, when there's no reasonable suspicion found, I think it can be done on a case-by-case basis. I think there can be cases where there's a finding that there was no reasonable suspicion and a prosecution of the officer wouldn't necessarily be warranted. But that's not
like what?
There could be a traffic stop, and the facts are just not there. You're charged with something, not necessarily the resisting or any assault that comes afterwards. But I don't necessarily think all of those type cases would warrant a prosecution of the officer afterwards. As far as investigating officers on the more serious things, yes, General Assembly does make it to where you have to have an investigation. There should be a standard of prosecution that's higher than beyond a reasonable doubt. Now, the fact that there is an investigation required of officers means your information is going to be better when you make that decision.
So let me be clear. You believe that the General Assembly has set the standard for police prosecution?
No.
Higher?
No. General Assembly has made the law that there has to be an investigation before there's charge of an officer. And so I'm just saying the result of any time you have more of an investigation before you make a decision, then the decision is going to be more informed. But that standard, whenever you make that decision, to prosecute should be higher than just probable cause, regardless of whether or not it's an officer or a person.
What about building self-defense into the decision whether or not to charge? Because I have folks who claim self-defense and who are civilians, but have to try that in their case. But officers seem to have built into the decision not to prosecute their own assertion of self-defense.
Yes, you do, but you also don't get many cases to where when the prosecutor makes a decision not to charge an individual because of the self-defense claim. I've made decisions often not to, I made the decision to tell the officer that we would not prosecute a case that never got charged because the self-defense claim, or it was clearly self-defense, or self-defense claim that we couldn't overcome. I know my time's up, but I would mention that, yes, I'm open to having the AG come in, but the AG does not come in unless there's a conflict. And there's not a legal conflict just because it's an officer in your jurisdiction. I've been turned down by the Attorney General. You can ask other jurisdictions to prosecute. I've been turned down by other jurisdictions. So while it would be nice for a lot of reasons to have someone else come and prosecute any number of cases, the Attorney General will not accept a case unless there is a legal conflict.
All right, thank you. All right, I want to talk about the criminalization of poverty. That's another issue that is troubling. It appears that the kind of justice you get can often depend on how much money you have, and that affects not only the kind of charges that exist, where people are charged for crimes that are specifically targeted for panhandling and trespass and sleeping in public and urinating in public. Other crimes disproportionately affect people because they're poor. People get a driver's license revoked because they couldn't afford a lawyer to handle the traffic ticket. They couldn't pay the ticket. Their license revoked. Suddenly they got a snowball of that. Now they're going to jail for missing court for a driver's license revoked. And if they had the cash, they would have been able to keep their license straight. There's also disproportionate fines and fees that are difficult to pay. You pay $250 for the privilege of doing your community service, and your court costs, are supposed to go to the schools, but they're going to pay for the overhead for the court system. And sometimes folks, may qualify for a deferred prosecution or otherwise some kind of treatment, but they can't afford the task fee, or they can't afford, they may want a certain amount of restitution up front before they get the deferred. In any number of ways, being poor really hurts a person's chance of getting justice. What is your position about that, and what things can you do as district attorney to minimize or remove the impediment that being poor places on people who are faced with our criminal justice system? And this starts with you, Mr. Meyer.
I think that is a huge issue. I mean, one of the problems that we see is what you see, the spiraling out of control. And court costs now are up to $190 in some cases, and then you have the fine and everything else. And now you have the General Assembly saying you can't waive the court costs to the judges, which causes a whole issue. And then if you make them a civil judgment, you seize their tax returns and spiral them out of control. I think a lot of that is where you would try to expand deferrals, informal deferrals, things like that, because if you dismiss charges after the appropriate consequences, that's about the only way we can control a lot of these costs and fines and things like that. So I think you need to focus on that. That's where you also use your position as the district attorney to advocate and explain to folks. That is what a huge part of the problem is. We need better mental health treatments. Like you said, are the poor have more issues? Yes, because they tend to have much more untreated mental health issues, untreated substance abuse. They're sitting in jail because they can't afford their bonds. They just decide to plead guilty so they can get out of custody as opposed to having the trial. I think you need to look at all of those. You need to work with them. Again, that's a part of, for the ones that we can control the costs and the fines, I think you try to minimize it. You don't ask for fines. For situations where it's appropriate, instead of having a conviction to get dismissals, obviously you can control the costs there. You encourage the judges to allow community service at a nonprofit again.
So would you dismiss just outright charges like panhandling and trespass and urinating in public, and dismiss driving a license revoke when it's clear as a failure to pay a fine and not a moving violation?
I think, again, you can't just say universally dismiss outright, but I think that's where have them do community service, have them look for something else, look for some other sort of consequences. But yeah, like with the driving license, that's what that amnesty program that they do. As long as it's not alcohol related, even then you have to look at it. look and see what you can do is there something else we can do that doesn't have to be a conviction that causes this fine? I mean, does it really matter if someone gets a speeding ticket conviction? You know, let them do driving school, let them do some other things, obviously within reason. So I think you have to look at the cases, and you do have to look at ways to lead people towards dismissals, let them earn those, and work with the judges to try to let them do waivers. We do have some forms now, and some judges are getting better about waiving those costs, and I think we need to challenge that. And I know the Southern Coalition, some others, they were using one of my cases to argue that some of these fees and costs are unconstitutional. We need to push that. And we need to work on fixing the General Assembly.
All right, Mr. Pickles.
I think charges like panhandling, I think soliciting alms, as you have taught me, sleeping in the park, things like that can be dismissed, and I typically do dismiss them. Now, I'll be honest with you, you may know better than I do how much or how less often those things are being charged as a result, but I think you can just dismiss charges like that that are particularly just directly associated with being poor. Some of the driving things, like driving while license revoked, I think sometimes you don't know until it's too late. Meaning, someone gets charged with driving while license revoked, they may not come to court. You don't get a chance to make that decision or make that determination. And yeah, that's what the amnesty program was about. Now, before the amnesty program and since the amnesty program, we still do that on a case-by-case basis. It's just you don't catch as many people who come to court as you do who don't come to court. That's spiraling out of control situation that people have when they, it's what we found with the amnesty program. It's better to not come to court for a ticket than to come to court and have a fine. But either way, you're looking at that $200 added cost, and then typically it ends up being, driving while license revoked after driving while license revoked. The other thing that we do is for driving offer often the take a class that's $20. That still costs, but it's obviously a whole lot less than $190 court costs, even without fine. I never object to the remission of fines in those cases.
All right, thank you.
I think we have to work harder to keep those cases out of court to start with. I don't know how many folks in here have had a charge dismissed, but it still shows up on your record. It still shows up if somebody searches for it. And so I think what the district attorney has to do is work with local law enforcement to really cross-train around what are the consequences of bringing poor people to court for these type of low-level crimes in which there are no victims and there is no damage to property. And really, we have to have a community conversation about who we want to be and what our values are. And are our values in the community that we want the police hassling people who sleep outside or urinate in public? Do we want the police interacting with those people in an aggressive manner, in a manner that results in some type of criminal charge? And I think the district attorney has to lead those conversations in this community and work against that. I don't think that the police will keep charging cases that get dismissed. And so I think if the district attorney is really clear, we have mouths that we can use. And we can use those mouths to talk to the chief of police, to talk to the sheriff, to have conversations about what are our priorities.
All right. So the next question will go back to you, Mr. DeBary, about juvenile prosecution. Actually, I'll go to Roger. I'm sorry, I'm getting out of my order. So there was a raised age bill that stopped prosecuting 16 and 17-year-olds as adults for many offenses, not all offenses, and doesn't really go into effect until 2019. It would require mandatory transfer to adult court for serious offenses. And in Durham, we have already kind of have a misdemeanor diversion program and a diversion program for folks started at under 18. I would keep kind of push that age up, and we're trying to get it to everybody. But my question to you about juvenile cases is, would you give effect to the principles of that raise the age bill now and not wait till 2019? And would you consider, for juveniles who are charged with offenses that would be a mandatory transfer, would you consider charging them immediately and substituting as their charge a lesser offense that would avoid that mandatory transfer?
Now, what I would do is look at every alternative that we could to not pin a conviction on someone under the age of 18, because I can't prosecute them as a juvenile, but there could be any number of cases that involve victims, could be any number of cases that are victims' rights cases that I don't think you could do nothing with, but I think you can look for alternatives to a conviction. So that's what I would be willing to do with that. And what was the second part?
Mandatory transfer. So when it does occur that some of these cases, depending on how juveniles are charged, would you consider charging them with a lesser offense or a related offense to let them stay in juvenile court and not automatically be transferred to adult court where they'll be convicted as an adult?
I would do it on a case-by-case basis. Now, I was in favor of a bill that would have gone further as far as the raise the age bill. I think it goes up to Class H, and there are arguments for and against why it should go higher. But I was at least in favor of going up to a Class E, as it looked like that was the preferred bill by many, and it didn't get that far. So, advocated for that within the Conference of District Attorneys as well as at the legislature, and that didn't happen. So certainly, feeling like that, I would be willing to plead down some cases in order that a 16 or 17-year-old can be prosecuted as a juvenile instead of an adult. But I think it would have to be on a case-by-case basis. I'm not even saying that I wouldn't do that with some Class D and above, but it still have to analyze it whether or not it was appropriate on each case.
All right.
I think your first question was, would I go ahead and prosecute based on raise the age? And the answer is yes. There's nothing that stops the district attorney from currently following that practice. As far as charging juveniles with lesser offenses, I think it is really important in those cases for the district attorney to slow down and to really take into account everything that needs to be taken into account before deciding on which charges to proceed with a juvenile, irrespective of what that juvenile has been charged with. And there are best practices across the country where that happens, and where, when appropriate, the juvenile is charged with a lesser offense. And so it would not be a stretch to do that here in Durham County.
All right.
I think similarly, I thought raise the age didn't go far enough. We should have joined the rest of the normal country and just raise the age. Until it goes into effect, one of the problems, I would like to adopt some of the principles of it and stuff, except unfortunately there is no mechanism to send someone 16 or 17 into juvenile court. They will be prosecuted as an adult until that time comes. Now you can work with deferrals with things like that to try to help prevent the convictions, but there is no mechanism until the raise the age goes into effect for me to send a 16-year-old or a 17-year-old to juvenile court. Once it is in effect, I think you do need to look at the cases, you do need to analyze them. If it's a case where, because H's and I's is where it stops, there's some fairly low-level victimless stuff and things like that that are above an age. I think you need to look at the cases, you need to look at it and look at the facts of the case, deal with the victims. You've got to consider a lot of the stuff. I mean, as prosecutors, we have to take into account victims as well, not just the defendants. And if it's a case where a resolution, a plea down to a misdemeanor or an H or an I is appropriate, then I think you do look at it and say, you know what, rather than transfer this to an adult court and then give them an adult misdemeanor, reduce it ahead of time and try to keep them in juvenile, certainly once the raise the age has come into account. I think you absolutely would need to look into that and determine what is appropriate. Prior to that, I mean, like I said, unfortunately, we can't prosecute 16 and 17-year-olds, so I would look at deferrals, diversions, do whatever else you can to try to help them avoid the adult convictions. And another thing is, we've said of using the bully pulpit, North Carolina finally started expanding their expulsion laws. They need to go further. I mean, it's still odd that, you know, a not guilty or a dismissed charge follows you forever. You can now get more of them expunged, but I think we need to expand a lot more of that. We also need to keep advocating for fixing the raise the age and seeing if we can't get them to hopefully expand it even more. Hopefully this will be a success and the General Assembly will look at it. Like I said, a lot of what we need to do is focus on the General Assembly.
All right, I think my next question goes to you, Ms. DeBary, and it has to do with the death penalty. The death penalty is a lawful possibility in our state, although we have not had a conviction or an execution in many years. The cost of that, the economic cost of that, just the cost of prosecution from the defense.
Capital murder cases were the most immoral, racist thing in which I ever participated. And I have said that I would not use my discretion to charge capital murder. I think it is impossible. I think there is no equity in that. It is impossible to ensure that there is.
All right. Mr. Meyer.
Yeah, I mean, I've said the same thing. It doesn't work. It's not a deterrent. It's a waste of time, energy, effort, and resources. If someone's guilty, life without parole means life without parole. We don't need to give them the notoriety of the trial. We don't need to give them the spotlight that it keeps coming. I would have no intention of seeking the death penalty. It doesn't work, and it's a waste of time, energy, and effort.
What about charging death penalty in order to kind of have some negotiating room to get the person to plead to life without parole? Would you do that?
No, I think that ties into a different issue that you may or may not get into of the whole plea abuse thing. I think you should make fair charges, not hit somebody with more serious things to make them plead for this, because that's a problem you see now where it's, well, if you don't take this 6-year plea, I'm going to hit you with violent habitual felony, you're facing life without parole. It's not just to go from a 6-year plea to life, things like that. So no, I wouldn't use the threat of killing somebody simply for leverage. If you have a strong enough case and you want life without parole, maybe they won't take it, maybe you have to try it, but you know, we try murder cases all the time. So no, I don't believe in pleading. I don't believe in using pleas in an abusive way to force, charges in an abusive way to force pleas.
Mr. Eccles?
I wouldn't commit to not ever doing it. I certainly don't think it should ever be considered, and unless it's the most heinous of cases, and certainly would consider any number of factors before making that decision. I've had to make that decision in over 100 cases as district attorney, and only made the decision to declare one that way. When I came into office, there were 3 capital cases, and I removed the death penalty from all 3 of those. So some of the things that I would consider would be certainly the strength of the case, the number of aggravating circumstances, the strength of the aggravating circumstances, the number of mitigating circumstances, the strength of those as well. I do think that decision does fall within the victims' rights statute, and so what the victims would want would be a factor, but not determinative.
All right. My next question goes to Mr. Meyer. I've showed up to court before and had someone in the audience kind of asking for help, and it turns out they were a victim of a crime, didn't know who to talk to, had got a subpoena. Turns out I represent the person charged with hurting this person. And they had to sit in the same room during counter call in district court. They had to answer witness present when the defendant's name was called. The DA didn't even know their name. And then the DA didn't even talk to them until they had to have a trial. Because it was going to be pled, the odds are they didn't even get that discussion about a plea that had been offered in advance that had been worked out. What could be done to help victims of crime negotiate this, particularly in district court? And is there a way that they could meet with district attorneys before court, be placed on standby, have the courtesy of being treated as people who've been harmed and not, victims who nobody wants to talk to until they need for trial?
I think that definitely is an issue, and a lot of that is you just have to deal with it on the administrative side. I mean, obviously, if the district attorneys have contact information for them, they should be trying to call them. In DV court, they do a good job trying to call them in advance. They need to expand that in some of the other areas because it is an issue. Within the courthouse, obviously, one of the big frustrations that many of us have is we have this nice back hallway that has all this stuff that no one's allowed to use. Because it is something odd about having victims, witnesses, victims and defendants sitting together and having to leave and use the same door. I always complain in jury trials that I have to use the same restroom as the jurors during the breaks, and that's never made sense to me. I think you need to set a culture in the office. There needs to be more contact. You need to make sure that the people have reached out to the victims. Have the district attorneys get there a little earlier in the morning and call and say, are there victims here who need to talk? They don't need to show up for court 5 minutes before calendar call and say, I'll talk to you in an hour and a half when we get to our break. Some of that the victims are obviously going to have to participate in, but some of it I think the district attorneys could be more available. They can use email. They all have victim witness legal assistants. I know there's not as many for district court. Perhaps they need another 1 or 2 assigned to that. Because victim communication is critical. Making sure they understand the process is key. It's not fair to them. And I've had the same situation where someone's asking you questions and you find out, oh, yeah, no, I really can't talk to you. I think you definitely need to have more focus on the victims, more focus on the contact, use of email, have a legal assistant down in court to talk to the victim. Instead of just having the 2 DAs in 4D, have the 2 DAs and a legal assistant to say, hey, if you're here under subpoena, if you're a victim witness, let's go talk. I think there's some small things you can do that would go a long way to help that.
Couldn't they at least look at the court files a week before and pull the ones and have the victims' names and address and phone numbers that are in the warrants and just call these people?
Well, I think that's what they do in DV court. And I think that would be good, is to kind of plan it a little more. And that's one of the things I've said with district court, and then I'll stop, is we need to provide at least basic discovery of police reports to the defense as well. If you look at the cases ahead of time, we can solve a lot of the log jams that we create.
All right, thank you.
If you Google a Durham County District Attorney's Office, you might get a picture of Mr. Eccles, but you won't get direction as to who works in that office, how to contact anybody in that office, how to advocate for yourself if you're a defendant, or if you're a victim. And I think that goes to the issue of openness and transparency in that office. I think it takes now 3 to 4 years for a violent case to go to trial. During that time, the victims and the families of victims have almost no information about what's happening. And I think that is one issue of management. I think if you are running a shop, you're responsible for everything that happens in that shop. And one of the things that should happen is that if you represent the people of Durham County, people of Durham County should be able to get in touch with you and talk to you about what is going on if they're a victim in a case. I think one of the ways to do that, I agree with Mr. Meyer around open files in district court, but that would require that they look at the cases before the cases come to court. And that is not often the case. Here in Durham County, we even have murder cases that are dismissed on the eve of trial because nobody's taken the time to actually look through the case and see if they have what they need to prosecute the case. And so what I would advocate for is really some management changes and certainly maybe a team approach to preparing cases for court. It is difficult in a fast-paced environment to prepare a case all by yourself. And so one of the things that I would do is institute some type of regular team meetings where we look through the cases as a team and make some decisions before court.
Question as it relates to district court, yes, there's a file prepared for every domestic violence case, and certainly that being especially court, sure, there's more attention paid to that, and even a lot of attention paid to witnesses in the serious traffic cases. There is contact made, not necessarily in every case with the other misdemeanors, but oftentimes we don't get contact with victims until court, which is often not lack of trying. I would say that there could be more regular announcing or trying to determine if there are witnesses present, before court and maybe at breaks to see what's going on there. But sometimes there is contact with witnesses, and you wouldn't think there was contact when you come to court. Just like when I go into court, I get contact with the victim and with a defendant, and I would never know that they had contact with you, but they're still asking me a question. So, of course, we should always look towards that. I would say in response to serious cases, or violent cases, it's not an average of 3 or 4 years. It's not close. Now, are there homicide cases that are old, or some that are that old? Yes, but of course there are some cases where we're not getting the labs back until 18 months or plus. There's cases where we hadn't gotten a report from the defense for years after. But there's no dismissing of a case on a murder case on the eve of trial because the case hadn't been looked at. So that's my time, so I'll put it.
All right. I think I will move on. So my next question has to do with habitual felon prosecutions. Habitual felon is a law that enhances penalties for many years for folks who have 3 strikes, 3 prior felony convictions. And I have seen that in our county used in nonviolent offenses, for drug offenses. Back in the day, I remember getting threatened with a prosecution with a predicate offense for felony FTA as a predicate for habitual felon. I don't know that we're there anymore, but still, it seemed like for a while that putting people away for a long time was the goal, and that predominantly people of color were the targets of that kind of excessive prosecution. What are your positions on when it's appropriate to use habitual felon the statute to enhance people's penalty, and could you agree to only prosecuting people who have violent charges against them and also only have violent predicate felonies, and that you would not use drug offenses or crimes of poverty or property crimes as predicate offenses or the basis for habitual felon prosecution? And I think I'm with you, Mr. Eccles, although I've got out of order on my questions, and so at this point maybe a crapshoot who asks first.
I think so. I think it's with me.
Okay, all right, go ahead.
I think you look at, well, I look at factors, and I've told staff to look at different factors. Yes, you look at the predicate felonies. One, if there's no violent felonies, it certainly should be less likely that you consider proceeding on a habitual felon. If it's only the first time that they could have been prosecuted as a habitual felon, it's less likely as well. One of the main things is the underlying case. Some cases, someone is a habitual felon, and the facts of the case are very provable, and it's not even necessary that you prosecute them as a felon. You could have obtaining property by false pretense. That's a $10 case. Or you could have a removing a tag from clothing or something else. That's a felony that doesn't even need to be a felony.
Like removing a statue.
So you could have any number. You could look at any number of those things. I think typically, if we're looking at a violent case, I wouldn't agree that no case should be prosecuted as a habitual felon unless it's violent, because I think most of those are going to reach that level without attaching the habitual felon to it. If they're convicted of that, I don't think the habitual felon in most cases will make any difference. I will say that I looked at the numbers, and I think there have been 21 habitual felon prosecutions since I've been district attorney. And because of the period of time we went through, I signed every case for a few months, and in doing so, I would look at the record, at least a cursory look, and I would say on average 20 to 30 a month that I would look at. So we're talking about hundreds, several hundred that would qualify, and there's been 21 prosecutions in just over 3 years.
All right, thank you.
I think that goes back again to having a prosecutorial policy that is clear and understandable, that every ADA follows, and that has been developed in conjunction with the community and with law enforcement officers. I think the habitual felon has been used as an unnecessary enhancement, it's often a way to overcharge and coerce a plea bargain. And so I am not in favor of using that enhancement. And I think even on violent cases, if they are charged correctly, the habitual felon enhancement may or may not be necessary. But I think you would only consider it for violent offenses and people who have a record that would indicate you would even consider it.
I mean, I think my response would be fairly similar. I do think, again, the habitual felon, kind of like to raise the age on the juvenile, is something that the General Assembly finally took some steps to fix the harshness of. Now it's not an automatic C, it's a 4-step increase. But I think that still creates a lot of problems. I think you need to look at the predicate felonies. I've had felony FTA threatened. Another issue you run into with habitual felon is, the way that why do prosecutors always want you to plead guilty to 2 felonies instead of 1? So they can use 1 for your record level, 1 to set you as a habitual felon. Because otherwise it would drop it down, and then they always choose the I for the habitual and leave the H or the G. I think you need to look at each of them. You need to see what the predicate ones are. I think you do need to have the policy. And I mean, if it is, if the guy's got the class I possession of cocaine and that's basically all he's had, I don't think you jack him up with it. If his predicate felonies are 20 years ago, he's been out of trouble for a long time, I think you need to look at it individually. Sometimes it's appropriate, a lot of times it's not. I don't know if that 21 includes having gone to trial, because I've certainly had it charged a lot of times in my cases. Although a lot of times we end up pleading to different things. I think you need to use it very sparingly. Again, on some of the more violent offenses, sometimes it really doesn't change things, depending on what they're charged with. Charging someone with murder and habitual felon, you're wasting everyone's time. But I don't think for non-violent, I'm assuming you're only talking about habitual felon, not the actual misdemeanor assault, DWI. I think it should be used sparingly. You need to definitely look into it. If someone's felonies are non-violent, low level, I don't think you should suddenly say, hey, now you're, like you said, you removed a tag from a $2 piece of clothing at Target, that's a felony, now we're going to send you to prison for 5 years because we can. I think you need to be very careful with that, and it should be reserved for the worst of the worst.
All right. I think I'm to you, Satana, I think. All right. So I want to ask about restorative justice. That's something that near and dear to my heart. We have students here who are in my restorative justice class and have helped start what's going to be hopefully a clinic here at Central where students help with religious coalitions work around restorative justice. People use that word and it's kind of becoming a fun word to use but don't really know what it means. But it's a process that asks the first question of how people have been harmed and what is needed to heal that harm. And then it asks how we can hold them accountable for healing that harm in a way that keeps them within the community and also involves the community in the resolution of that process. And the way that looks is often conferencing, circle conferencing, victim offender conferencing, that's mediated by a facilitator. What is your position on when and how restorative justice could be integrated into the criminal cases, and how would you go about doing that if you are in favor of it?
I am in favor of it. And I think the way in which we would use it in my office is I continue to say that we have to have a prosecutorial policy. We have to work in conjunction with our community. I think the first way to do restorative justice is that we do have to work with the community and how we develop that prosecutorial policy, right? That we work as a community to decide what our values are and how, as the district attorney's office, we can keep everyone in our community safe while still holding people accountable. And so I think that is the first way is to work with a community. There is an example in Brooklyn where the district attorney has convened a community panel that includes everyone. So it includes law enforcement, it includes district attorneys, it includes defense attorneys, it includes religious leaders, it includes community leaders, neighborhood leaders, and really what are our values as a community, and what do we think restorative justice is, and what would that mean for us here in this community? And then I think you have to have a district attorney's office there that's committed to taking the lead in following that. And rather than waiting for the community to come to the office and propose things, that the district attorney takes the lead in training. I would train myself as well as my staff in what restorative justice means and how we would fold that into our policy.
All right.
I mean, I think restorative justice is a good thing. It ties into what I've said. What are the appropriate consequences for the actions? One of the first things we need to do is make sure people understand restorative justice doesn't mean you're letting the defendant get away with it. Restorative justice is actually geared more towards the victim of the crime. We have this, we tend to ignore them and ignore their hurts and say, hey, if we get you conviction, you're going to be fine. A lot of times that's not what they need. I run into it in civil cases. You do a wrongful death case and you say, look, I know money can't ever replace your lost child, but that's all that this court's ever going to grant you. If you need something else, you need to look for more. And I think restorative justice does that. I think you need to be careful that it's victim-driven. You don't want to force them into it or make them feel bad if they don't want to have anything. Maybe they just want that conviction and I'm done. But sometimes they do want to talk. Sometimes they do want to have other things. We had the case that was done recently. It's not often that somebody goes and turns themselves into the police before they're even looking for them and says, I'm the one you want. And in that case, the victim's family was obviously looking for more than just, let's lock this guy up and throw the key away. And I think with restorative justice, that's what you would look at, is work with the victims, work with the community, work with the stakeholders, and see, what can help this person heal and overcome the harm that being the victim, that this offense caused them. Because at the end of the day, obviously our laws are designed to protect society, but they are also intended to help the victim and help the victims recover. And restorative justice can give the ones who, for appropriate cases and the ones who want it, other avenues to help them get beyond and essentially restore themselves to where they were before this happened. And I think it's a great principle. I think it's something that in appropriate cases should certainly be expanded.
All right.
First started having conversations with the Religious Coalition for Nonviolent Durham about restorative justice probably a little more than 2 years ago, and it was maybe a year ago, a little more than a year ago, when there was an information session and that they contacted me about, and sent 3 prosecutors, a juvenile prosecutor, a property crime prosecutor, a violent crime prosecutor, and at the time they were talking about doing it in juvenile cases and some low-level cases, and pretty much at that time, that's when we brought to them a major felony right then. Since that time, I'm working on 3 other felonies, and we started discussion even on a homicide case as a possibility. But next steps would be to develop some policies, but I think those policies would be around the cases that we seek as prosecutors, because you can't force a victim into it, and it really does become about the victim in restorative justice. So those type cases where there are victims and there are victims who are willing and you have to be perceptive that are looking for answers more than just what is this defendant going to get, or the type case that we have to look for, because we have to be intentional when we're looking for those type cases. We also, when we're talking about training, sure, we have to know what to look for, but we have to work with the defense also, because it can become a collaborative effort to find those cases that are appropriate for restorative justice, and prosecutors have their part, and defense attorneys have their part also.
All right, well, I want to thank you for all of that. With respect to restorative justice, I can say we've got some students ready to train y'all, so we can get that covered. I also can say that restorative justice is not just something that can happen at the plea negotiation stage, but it's also something that can happen at the pre-trial or pre-charge diversion stage. It can happen at the sentencing stage. It can happen while folks are in prison. It can happen on reentry. And so I encourage you to plant that seed in your minds as you look at alternatives to incarceration for our community. I would like to give you all 2 minutes each to kind of give closing remarks, and then I'll thank everybody for coming. So I think I'll go in virtually this time and start with Mr. DeBary for your 2-minute closing.
Good. I thank y'all for sitting here tonight. I know it wasn't easy to sit here and listen to kind of us go through the technicalities of the criminal justice system. But I think what I would like to say at the end of that is that this is really about who we want to be in Durham. We like to brag about being the most progressive city in the South. We have a city council that likes to talk about how it's moving forward. We cannot do any of those things if we leave our most vulnerable people behind. And so what I am proposing to you is that we take our values and we transcend the gap between our values and what we do every day in criminal justice court, and take the lead and be a more progressive community, a community that doesn't prosecute people based on racial disparities, that doesn't spend time trying to herd children in the court, that doesn't spend time trying to prosecute property crimes that are meaningless and that end up destroying people's lives. That we spend our time as a community trying to heal ourselves from the racial injustice that we've experienced over the last 400 years. That we take the lead in trying to be a community where we address harm when harm happens, but that we're accountable for how that harm is handled. I've said this before, and this is our last forum, and I would be remiss if I don't say it again. As the black mother of black children in this community, I cannot stand the way that we do criminal justice. I cannot stand that I have a child that I'm afraid to send out to drive by herself. I cannot stand that even I, with all my experience in the criminal justice system, pulls off the street when I see a police car. And so what I ask you to do is to think about who you want to be and who you want us to be. Thank you.
Thank you. Again, it's been my pleasure to serve as your district attorney. I will say at the beginning, I've never prosecuted anyone because of their race or anything of that nature, and I would not tolerate anyone working for me who did so. During my tenure, we have done a lot of things. We have created stability, and we have worked towards a criminal justice system that we can that we can believe in, and that we know that the people inside of, and certainly the people inside the district attorney's office are acting and making decisions based on the law, the facts, and being fair. There are many things that are being or that can be proposed, and some of those things can be practical, but some of them are certainly impractical. We do divert a lot of things, but when we want to say we want to divert things that other things and many other things, we have to ask, what are we diverting things to? Because law enforcement diverts, and if we don't have anything to divert to, we're not handling any issue that there is. There's certainly more work to be done, but there's work that has started during my administration, and I would ask to continue that work as we work to better ourselves and make our community a better place to live for all of us, and certainly make it a safer place to live. Thank you.
And I think, yeah, thanks for having this. I think this is the last one we have scheduled. We do need to work on making Durham better. We do need to keep moving Durham forward. We have been making some progress over the years. It's time to take it on to the next step, and we need to make sure we work with all of the actors within the process, the judges, the law enforcement, the victim. Right now, Durham is having issues. Asians feel like they're being targeted. Hispanics feel like they can't be safe in their homes. They're scared to come forward. We need to focus on all of Durham, do the racial equity training. People shouldn't feel they're being targeted for race. They shouldn't be targeted for race. We need to help them deal with the poverty issues and things like that, deal with the prosecutions, deal with the stops. And I think that's where I can help with that. We need to make sure cases move efficiently through the system. Low-level offenses, see if we can divert them, see if we can do other things. The high-level stuff, make sure the cases are moving. Make sure we're working with the investigators. Make sure we're working with law enforcement so the violent criminals are being prosecuted quickly and effectively. Make sure we're working with the community to make them feel safe. One of the best defenses in a violent felony in Durham is a reluctant witness. We need to help make those witnesses feel safe coming forward, and they don't feel safe if they know it's going to take a year, 2 years, 3 years for that case to go to trial, and during that time, that defendant's friends are threatening them and doing other things. So I think we need to work on bringing all of it together. Like I said, Mr. Eccles has done some good things moving us forward. I think it's time to move things more forward, and I believe that I can do that. I've got the experience with the defense. I've got relationships with law enforcement. I've got relationships with the judges, the clerks. I've got the prior experience. I think it's time to take Durham on to the next level.
All right. Well, let's give everyone a round of applause.